My name is Mary Kate. I'm coming to you all today from the Farm Credit East office in Homer, New York. I work as Farm Business Management Specialist for the South Central New York Dairy and Field Crops team. And I feel really privileged to be here today to speak with you guys about this topic because it's a really important topic, but it's also one that we don't really like thinking about or talking about very much. So I really commend all of you who have chosen to spend a big chunk of your day here today because it's important stuff. So for those of you who are still deciding whether or not this is important to you, I just want to give everybody a reminder why prevention of sexual harassment in the workplace, including on our farms, is really critical. So number one, sexual harassment, like all forms of harassment, is harmful to people. And so we don't want our employees to have to go through that experience, right? Use the golden rule, and we want that to apply on our farms. From a business standpoint, happy employees are productive employees, right? So we want to be sure that in order to have a productive atmosphere on our farm, that we have a culture on our farm that is prioritizes safety and respect for our employees. We've got the liability standpoint, right? And Kelsey O'Shea's presentation is going to delve deeper into this area a little bit later today. But it is a real risk that farms face as far as being held liable for the actions of your employees in your workplace and how their effects on other employees. So finally, and this is the reason why we're having this presentation right now, is that there's some new regulatory provisions here in New York State that are forcing employers to think about this and bringing this to the attention, especially some of our smaller employers, farm businesses that haven't necessarily delved into this topic in the past. So now it's actually the law. We have to do some new things. We have to take some actions in our businesses to comply with state regulations. So we're not going to spend a lot of time today talking about what is sexual harassment, but as farm operators or HR specialists, you guys are going to need to make a decision about whether or not you're going to be training employees yourselves in-house or bringing someone else in. And so it's good to just have a little refresher of what we mean when we talk about sexual harassment. So we've got a little quiz here, and you can read along, follow along, and sort of gauge yourself, do a little self-assessment on how much you know about this topic. So workplace sexual harassment is a form of discrimination on the basis of sex. That is true. That's essentially the core of the definition. Workplace sexual harassment is unlawful. That is true, right? So there's the New York State law outlaws these certain practices or defines these practices. Sexual harassment only happens to women. Hopefully we all know that that's false. So both men and women can experience sexual harassment. Both men and women can perpetrate sexual harassment. So that's an important reminder. Sexual harassment includes harassment on the basis of sex, sexual orientation, gender expression, gender identity, and the status of being transgender. That is true. So it goes beyond just if you're a man or a woman, but certain other aspects of sexuality and gender identity are also covered. Sexual harassment can create a hostile environment that interferes with a person's ability to do work. That is also true. Sexual harassment always includes physical acts of a sexual nature. And that one is false. So it can be visual materials displayed in the workplace that are inappropriate that can cause a hostile environment. And comments, of course, verbal exchanges also can create that sort of hostile environment. And then sometimes sexual harassment involves harassment based on stereotypes, sexual stereotypes about what men should do and what women should do, how men and women should behave. So that is covered under sexual harassment. Okay, so the reason, again, that we are talking about this today is that we had some new provisions passed as part of our 2019 New York State budget. So lots of things go into that budget legislation. And in that legislation, there were 6 specific provisions, 6 specific sections that were included to combat sexual harassment in the workplace. 5 of those affect private sector employees, or employers, excuse me, private sector employers, including farm businesses, and there's no limitation on size. So this affects folks, both large and small employers. So what I'm gonna do now with the rest of my time is just work through what are those 5 provisions. So you get an overview of everything that is in the new law affecting private sector employers. And then I'm also gonna talk a little bit about which of these provisions are gonna affect your farm. Okay, so some of the provisions are gonna have a big impact on farm businesses, and some of them are really not gonna apply to most of our farms just because of the type of employers that we are. So the first provision in the new budget is it expands human rights law to cover more people in the workplace, right? So we talk about the employer's responsibility to their employees to protect employees from sexual harassment in the workplace. Well, now other people that do work on your farms but are not your direct employees are also protected. So for example, we see on farms a lot of people coming onto your farm and doing work, whether it's custom harvesters, veterinarians, nutritionists, crop consultants, bookkeepers, all sorts of folks that come onto your farm and you're hiring them or contracting with them to perform some service. They are protected when they are doing work for you in your workplace. And that also means you as the employer are liable should they experience some sort of harassment. So if you know about something, you are required to take action. So provision number 2, the new state law prohibits mandatory arbitration around sexual harassment claims. So what is mandatory arbitration? This is used oftentimes when employees sign an employment contract, and it's a contractual agreement to settle disputes through a process with an arbitrator rather than through our court system. Okay, so how would this affect a farm business? If you have an employee sign an employment contract, this is something that can no longer be part of that contract. So most of our farms don't actually use written contracts with employees, so it may not be an issue for you if you don't have an employment contract. If you do have an employment contract, it would be good to have your attorney review it to ensure that it is up to date with the new laws. Okay, provision number 3 out of 5. The new state regulations limit non-disclosure agreements when settling a sexual harassment claim. So, what is a non-disclosure agreement? This is another type of contract between 2 parties who where a big corporation wants to protect its trade secrets. So when they hire an employee, they have a non-disclosure clause in their contract. That's not what we're talking about here. Non-disclosure agreements can also be used as part of a settlement process. Okay, so if your employee sues you because they experienced sexual harassment while working at your business, some businesses will attempt to settle that claim and try to also include a non-disclosure agreement as part of that settlement process. So asking the person who has that claim to keep confidential the information about their claim and about their experience on the farm. New York State has decided that non-disclosure agreements employers can no longer force that upon employees when settling a claim for sexual harassment. So this would only come into play on your farm if you were in a legal dispute around sexual harassment and you're working towards a settlement. you are not permitted to require an employee to sign a non-disclosure agreement. So hopefully this will not apply to most of our farms, but just important to know about as part of the new legislation. Okay, number 4, and this is what we're going to spend most of our time talking about today, because this is the one that affects all of our farm businesses that have at least one employee. So New York State has come up with new policy and training requirements around preventing sexual harassment that require employers to essentially do 2 things. One is to adopt a written policy that states how your business is going to work to prevent sexual harassment and to have a process for folks to report it and resolve any issues, investigate and resolve any issues that come to light. So the deadline for adopting this policy was last October. So y'all have policies, right? Hopefully. Okay, so yeah, 90% of the people in my room are nodding. So if you don't, you need to get this done as soon as possible. And New York State provides a model policy which you can take and implement right away with some minor updates to customize it for your farm. So if you haven't done this yet, put it at the top of your to-do list. So the other component here is, in addition to having a policy, you actually need to provide it to your employees, and you need to provide some training about what their rights are and what the expectations are for them to report an issue and the process for them to do that. So the deadline for the training, while New York State says we have to train employees annually, right? And so we have until October of this year to implement a training process to train our employees. And then after that, it must be done on an annual basis. So you're going to have to come back to this multiple times. And then, so I said, remember, there were 5 new provisions that apply to employers in New York State. The last one just applies to contractors. So folks who provide contract services to the state, they must affirm that they have their policy and training in place, right? So that they've met the requirements of that 4th provision. And this only applies to folks that provide contract services to the state. So we just had a quick question here in the room about this, if it must be a written affirmation, or how would you affirm this? And I believe that it is now incorporated into the bidding process for contractors. So if you were going to submit a bid for a contract with New York State, part of that would be to sign an affirmation stating that you have met these requirements. So you cannot bid on a project unless you can affirm that you've met these requirements. This is New York State contractors, yes. Okay, so I think this is my last slide. I just wanted to review quickly the timeline for some of these the rollout of these provisions. So going back a little bit, it was April 12 of 2018 that this law the budget was signed into law by the governor. We already said that October of 2018 was the deadline to implement your sexual harassment prevention policy and provide that policy to your employees. January 1st of 2019 is the deadline for New York State contractors to have implemented the policy and training, and that has been a requirement for applying to through the bidding process for state jobs. And then the last date on our timeline, which is fast approaching, is October 9th of 2019. And this is our deadline for implementing our employee training program. So I will stop there.
I know this is, and what a great summary Mary Kate just provided of what the overall requirements are for us. And obviously some of those requirements started already October last year. The other one, the training requirement, is October 9th of this year, that you're supposed to have all of your employees trained. So there's been a lot of confusion, a lot of concern, a lot of challenges across the state from farms and farm businesses that want to put the training into place and do the right thing, but not sure about exactly how to do that in a way that is compliant with state law, and maybe more importantly, how to do that in a way that is very effective with farm employees. Because we're doing this, yes, because it's required, but as Mary Kate stated, because it's the right thing to do too. I mean, we want to make sure that we are creating a harassment-free environment on our farms. So how can we do the training in a way that's going to create that harassment-free environment? So the state has a website out there that has a model policy and training available from the state. That policy, you can simply take it and adapt it to meet your needs. And you're not absolutely required to use the state's model policy. You know, you could work with an attorney to develop your own policy, or to adapt a policy you already have. But most people are picking up the model policy and adapting that and putting that into place. You can put it right into your handbook if you already have an employee handbook. And actually, that reminds me a little bit. So Mary Kate was talking about those arbitration clauses. It's not uncommon to see those in handbooks, in employee handbooks, which is not necessarily a contract or an agreement in that way with the employee. However, it is not uncommon to see arbitration clauses in there. I think that's something you need to revisit, and in many cases remove in the context of, certainly in the context of sexual harassment, because it's not lawful anymore to have that as a requirement for a sexual harassment situation. But increasingly, that's something that's not available for employers to use. So look at your handbook, see if you have a clause in there, talk to your attorney that you do work with on that about whether or not you should have that arbitration clause in there or not. So with the idea of helping to make this training more effective for farms and for farm workers, we decided that it needed to be changed a little bit, tweaked, so that it would fit better for the farm environment. Because, hey, well, we're in an office. I assume most of you are in an office setting, and the actual sexual harassment scenarios that might take place in an office are actually quite different from what might take place on a farm. But the reality is it can and does happen on farms as well. So a group of educators work together to develop what we call farm-focused sexual harassment training. So it's modeled after the state materials, but we've just made strategic adaptations to that to fit it into a farm environment, so it's going to make more sense. So I want you to picture your employees. You or another consultant is coming in and helping you to do your training on your farm. And these are farm employees that are working in milking parlors, out on tractors, with livestock in barns and so forth. And suddenly we're talking about an incident of sexual harassment around the water cooler in an office situation. How much will your employees relate to that? Not so much. So that's, we're anticipating that and saw that happening on farms already. So that's what we were trying to address, to make it a lot more relevant for farm employees. So farm-focused sexual harassment training, it is modeled after the state, and the state has reviewed it to make sure that we continue to meet all the state requirements. We also, I'll say, simplify the language a little bit. There was a team of attorneys that wrote the original state's model training, and we were able to make a few modifications there to take some of the legalese out of it and bring it back to a more I'll call it human type communication, right? And so we were able to do that and still have the state's approval for it going forward. So before we jump into that totally and into exactly how to use those materials, briefly I want to review what the state provided resources are. This website that's up on the slide right now will direct you to the model policy, which is out there, which you can adapt and put into place. The model training, which has both presentations, like PowerPoints like this we're using here now, and also recorded videos that is a person talking with those presentations. So an employer wouldn't necessarily have to do it as a presentation. They could show the video for their employees. It also has translated materials, and all of us educators have been getting lots and lots of questions about where can I find those translated materials. Just scroll down, scroll down, scroll down to the bottom of the page. They're there, and I think 7 different languages. You just got to scroll all the way to the bottom of the page on the state's website. It's a little awkward website, a little bit hard to find things, but it's at the bottom. Just keep scrolling down there, and you will find them. Okay, I wanted to share some thoughts and kind of a stepwise approach to getting the policy in place, getting the training in place, and becoming compliant on your farm. So first of all, put your policy in place now. Again, it was October 9th last year that it was required. If you haven't done it, just do it. You know, as quickly as possible now. Don't need to report anything to anybody. Just get that policy in place right now. And part of putting that policy in place is to make the edits on it that are required to customize it for your farm, and then get it into the hands of your employees. So that can be printing it out and providing it to them, or if you use some kind of electronic means, you can send it to them electronically, or you can put it on, if your farm has a website or some type of electronic software to manage employee communications, that's okay. And there's no requirement for it to be printed on hard copy. You can provide it electronically also. Provide the policy in writing to employees, set your expectations clearly. And again, that's part of it. You know, this is, as management, as leadership, set your expectations that we're not going to have sexual harassment here. And if we do, we're going to deal with it directly, quickly, and appropriately. Provide the combat harassment complaint form. That's another requirement. That form has to be made available. That is a state form that's available in multiple languages for you. You need to make sure that's also available to your employees. It's not required, but I do definitely recommend the sexual harassment poster, which the state also provided. Put that into the workplace and make it available, and that's also to be customized. Train everyone at hiring and annually. So Mary Kay talked about the annual requirement. There's no particular date when that is required, but you need to make sure that all of your employees are trained at least annually. Most employers are going to do that all together as a group just to be efficient. Others, if you use like an online resource, you may be able to train individuals at different times, and that's okay too. It just has to be once a year for all employees. Now, the other part of that sentence is new employees, right? So the state is not real specific on when the new employees have to be trained. It's the best practice that we've been recommending is that definitely within 1 month of hiring, if possible earlier than that, you know, within a few days. You know, you become liable as a business, you know, for making sure that no harassment is taking place right away as soon as you hire a new employee. So someone theoretically could be a brand new employee and start with some bad behaviors immediately, and hopefully that scenario wouldn't play out, but you'd still need to deal with it directly. So it's important to get that training in place. And the training for that new employee should be at least providing the policy, giving them examples of what sexual harassment is, letting them know that it's not acceptable, and sharing with them how to report sexual harassment. So you can do a lot of that with the policy when you provide it to them. This part we don't want to forget, number 6, act immediately according to your policy when there is a complaint or harassing situation. So this is not just putting a policy in place and just doing the paperwork aspect of it. You need to read that policy, understand what you are committing to as an employer, and the actions and follow through that you are committing to taking in the event that a sexual harassment situation occurs, because you need to do that. You need to follow through and act effectively against sexual harassment. So that's something I think that our management teams, our ownership leadership need to think this through and have a plan in place beforehand for how we are in effect going to address any issues that come up. We've already heard across the state that when employers did the training, put the policies in place, incidences of sexual harassment then started to come up. Not that there were new behaviors, it's just that suddenly employees understood, hey, this is sexual harassment, and I'm going to complain about it. And so employers needed to be ready and to deal with that immediately. And number 7, and Kelsey's going to talk about risk management certainly later, but document, document, document. I think in every presentation on any human resource topic anymore, we need to talk about documentation. You need to document exactly what you did in order to protect the business, in order to show that you took reasonable actions to deal with that sexual harassment situation, to correct it, resolve it, make sure it doesn't happen again, and to show that you had that reasonable follow through. So document. Have employee files either electronically or in hard copy, but show what you've done and exactly what steps you took. Some of this material then, or all of this material really ultimately will be posted at this website, the Ag Workforce at Cornell website, which you can see on that slide. So I encourage you to go to that site. Okay, let's talk about the state's training requirements, because it's not just, you can't just show a video for this one and then be done. There's more to it than that. So training must be interactive, and we'll talk about that more here in just a moment. It must include this explanation of sexual harassment consistent with guidance issued by the Department of Labor in consultation with the Division of Human Rights. So that's basically the definition that the state gives for what sexual harassment is, needs to be in that training. Examples of conduct that would constitute unlawful sexual harassment include information concerning the federal and state provisions concerning sexual harassment and remedies available to victims of sexual harassment. So in other words, what are all the remedies that are available? So there's certainly complaining to the employer, but there's also remedies about complaining to the state that an employee could take in order to follow up. And so that needs to be part of the training as well. Including information concerning employees' rights of redress and all available forums for adjudicating complaints. Again, this similar idea, how to go outside the business if they really need to. Include information addressing conduct by supervisors and any additional responsibilities for such supervisors. That's a key point that comes up in the training and is a key point for every business to understand, is that everyone who's a supervisor or manager in a position of authority or responsibility, they have an increased responsibility. First of all, they're supposed to model correct behavior and not be harassing people themselves. But if they even become aware of, if one of your supervisors becomes aware of a situation where sexual harassment has taken place, even if there's no complaint, then at that point, the business, because that supervisor is aware of it, the business is now liable and should be aware of that sexual harassment situation and should deal with it. So all your supervisors and managers have to be trained that even if there's no complaint, if they become aware of a situation, the business needs to address it. Okay, hope that's clear for everyone. And then required annually, beginning October 9th and every year after that. So interactive, a lot of questions, a lot of confusion about this, what the state meant by that. And when they put it out there in the law, it wasn't clearly defined. But since then, the Division of Human Rights and Department of Labor have offered these further explanations, which you can find this. I pulled this directly from their website. New York State requires all sexual harassment training to be interactive. Training may be online so long as it is interactive. And examples of employee participation include, in web-based training, if it asks questions at the end of the section, the employee must select the right answer. That's interactive. Further web-based, if employees have an option to submit a question online and receive an answer immediately or in a timely manner, that can also be interactive. For an in-person training, if the presenter asks the questions or gives them time throughout the presentation to ask questions, that will meet the requirement for interactive. So that's not a real high threshold there. There's an opportunity for questions, some interaction. You just need to create that space and opportunity for people. Also on a web-based training, if there's an opportunity for a feedback survey, that can also be interactive. So that's what the definitions are. And the training I'm going to show you that we've been adapting, it's going to be video-based, and we're going to build some pauses in there so that employers can choose to simply pause the video, ask for questions from the audience. And if you do that and interact with your people a little bit, you will have met that requirement. So you've got several options for conducting training. Libby Eiholzer later will talk about some other outside options. You can either conduct the training internally using someone from your staff, from your business, or you can use an external provider. That's up to you. There's the website again for the state's model training, which includes the videos, which you can certainly use. You can use Cornell Ag Workforce Development's farm-focused sexual harassment training. So that's the training that our team has worked on. I would encourage you to avoid outdated trainings or out-of-state trainings that may not meet the New York State requirements. They probably will not meet New York State requirements if they're coming from out of state, unless they're specifically labeled that they do. Question here in the room. It is. We have the materials in English and Spanish. We are going to record that in a video format. We just haven't quite gotten it done. We just got all the materials translated. So it'll be available within the next few weeks, I believe. But yes, English and Spanish. Now, we won't have it in all the other languages that the state has. But great question. So anyway, avoid out-of-state trainings or outdated trainings. There's a lot of trainings available out there on the internet. You can order videotapes and so forth and things like that. You want to avoid anything, even something from New York that is prior to 2018, because it probably doesn't meet the requirement. So let's jump into our Cornell Cooperative Extension farm-focused training. So simplified language, emphasis on why sexual harassment prevention is important, just trying to get the right mindset with our employees. Recognizable examples for farm employees and case studies that take place in farm situations. That's what our real focus has been. So how to use this farm-focused training to make sure you meet all the requirements and are effective with your employees. First of all, get that policy in place, customized for your business. I know we said that before, but I just need to reemphasize that, and distribute it to the employees. That's step one. Step two, customize and provide employees with a sexual harassment prevention policy poster. This is really important, and the reason is, okay, we developed this training and adapted it for the farm situation, but we can't customize it all the way down to your farm level, right? Because you've got several requirements, and I'll get into those in a moment, that you need to do for your farm specifically. So when we were putting the training together, we could customize it for a farm situation, but not to your specific business. So you need to do that for your business. And the two places you do that are in your policy and then in this poster, which is the same information that you're putting on this one-page poster. So we want you to do that poster and then share that with your employees at the time of the training, or showing them the video that we've prepared for you. It's not going to make any sense if you don't do the poster, because there's specific things in there refer to that one-page sheet that they need to have in front of them. Have a farm manager either give the presentation, which it'll be available to you, or show the recorded video, which we'll soon have in English and Spanish. You need to read through the case study. So there's going to be two parts, just like the states. There's a presentation, and then there are a number of case studies. I think it's actually 6 case studies that go with that. You need to do both, because the case studies really bring home the situations, the real life types of scenarios that can take place. The presentation part of it really address the sexual harassment overall, some of the requirements, what it is, and so forth. But the case studies really bring it home. So you need to do both. And then last, document that the training was completed. You need to do that. It is not, the documentation piece is not a state requirement, but it is a huge best practice, and it's something you need to be doing if you're not already. Okay, customize your policy. Again, this training won't make sense. The CCE training won't make sense unless you customize a few items for your business. So you can take the state's model policy. We didn't adapt that in any way. Just use the state's policy or one that meets those requirements that your attorney has reviewed. Change the yellow highlighted employer name text to your farm or business name. That's one of the first things. That shows up several times in the policy, and they've highlighted that in yellow. You can download it in a PDF, or you can download it in Microsoft Word. So there's a number of different ways to get it. You have to identify a designated person. Now this is an important piece of it too. So that is simply the person in your business that if someone has a sexual harassment complaint, they're supposed to bring that complaint to, either verbally or in written form. So who is that? Is it the farm owner? Is it an HR manager? Is it just another management person on that farm? It varies from one farm to another. Or if it's a small farm, often closely held family business, is it an outside person? It is certainly possible to designate an outside person. Maybe it's an HR consultant. Maybe it's your attorney that you work with in town. That could be the outside designated person, but you have to provide that contact information and everything to make sure that that's in place. So that's the challenge for some smaller businesses, is that, you know, if you got a business with 5 people that work in the business, who are we going to designate? Maybe there is a person that really fits and works for, but maybe we do need to identify someone outside the business to do that. So 1, 2, 5, and 6 on those pages are where you need to make those edits and customize that for your business. Step 2, customize your notice. It's called 2 things on the website. That's why I tried to say it a little bit differently in this format here. Customize your notice / poster. It's the same document. In one place it's called notice, another place it's called poster. But customize that for your business, and don't get confused on that part of it. The training refers to the sexual harassment prevention policy notice or poster for your business. And I've got the link there. You can download it directly in Word format and pull that up. Customize your employer name, the designated person, and that person's contact info, and the location of your policy and complaint form. So if someone wants to fill out the form, where they can get a copy of that. So likely have that in the office somewhere available or electronically available. Provide copies of the notice to your employees and post in the workplace. So this, again, the same thing. You can post it in the workplace and also give that notice out as copies to the employees. Okay. This is it. This is actually an image of the poster itself, just to show you, and it's one page. I cut off the bottom a little bit because it's hard to fit on a slide, but really this is all the information that's on there. So this key document for you to get in place for your farm. Give the farm focused presentation. So a farm manager or other responsible person can give the presentation, or you can show the recorded video. You don't have to show our recorded video. You can do it yourself. If you do it yourself, bullet number 2 there, keep this very professional and very serious. With this topic, it is easy for someone to start making jokes, and for that conversation and for that training to devolve into a big joke overall. Not saying it has to be totally that no one can have a little fun or a joke here and there, but the overall demeanor of this training needs to be serious, okay? Hope everyone's with me on that, because I don't want any farm to get into a situation where they've done the training, but it was all done in the atmosphere of this is a big joke. It's some state requirement and we have to just do this and we don't really take it seriously. Because you now are setting your business up for a lot of liability. Because if an employee is sitting in that room when all this gets laughed off is experiencing sexual harassment, that is not going to look good in court when it comes forward and there's actually a claim going on. So that's why, a big part of it, why we need to make sure that we take this seriously, keep a very serious demeanor about that going forward. Ask for any questions. This is a good time to begin establishing some of that interaction with the employees as we go through. So again, there'll be opportunities for pauses, and I'll show you an example of that here in a few minutes. But ask for interaction throughout and talk with your employees. Read or watch the case studies. So a farm manager can lead the reading and discussion of the case studies. Reading aloud addresses any literacy issues that employees might have. So, we might show the video because maybe you don't want to do that presentation part of it, but the case studies, which actually I think are printed in your handouts, you can read those aloud potentially with your employees, or you can watch the video that will make of that as well and pause at the appropriate points. But pause and discuss the true-false questions in each case study. And you can take as much or as little time as you want on that. Just make sure you do it in order to get the interactive piece in it. Yeah, and so we will build in some brief pauses after each of those true-false questions are asked. Let's look at an example. So this is example one of the first case studies, again, adapted from the state's policies. But I just wanted to share this and kind of give you an idea of how the pattern goes. So this is, just think as if we were doing the training now on your farm, and I'm the farm manager, and I'm up here leading this. In this case, I may play this video, or I'm going to go ahead and read that for this group. So example 1, not taking no for an answer. Nikki's coworker Ralph has just been through a divorce. Ralph works for the Johnson farm as a field manager. Nikki works in the farm office as the office manager. He drops comments on a few occasions that he is lonely and needs to find a new girlfriend. Nikki and Ralph have been friendly in the past and have had lunch together in local restaurants on many occasions. Ralph asks Nikki to go on a date with him, dinner and a movie. Nikki likes Ralph and agrees to go out with him. She enjoys her date with Ralph, but decides that a relationship is not a good idea. She thanks Ralph for a nice time, but explains that she does not want to have a relationship with him. Ralph waits 2 weeks and then starts pressuring Nikki for more dates. She refuses, but Ralph does not stop. He keeps asking her to go out with him. So I read that aloud. You don't know the literacy level of all your employees. There are people who are very low literacy, who can cover that up for years and years and years. And so you don't necessarily know that. But the fact that we just read it out loud, for English speakers anyway, puts us in a position where everyone's now heard that case study. So continuing on, if I were doing this training, I would skip to the next slide. When Ralph asked Nikki for a date, this is sexual harassment. True or false? Cortland? And the answer I'm getting back from Cortland is that it was false. Okay, so we paused. Maybe we discussed that a little bit. You are correct. It is false. So Ralph's initial comments about looking for a girlfriend and asking Nikki, a coworker, for a date are not sexual harassment. Even if Nikki had turned Ralph down for the first date, Ralph had done nothing wrong by asking for a date and by making occasional comments that are not sexually explicit about his personal life. So that's the pattern. That's how it goes with the case studies, and that's how you can definitely meet the interactive requirement for that. So number 5 then, document training completion. Let's talk about this for a moment. So if we've either worked through the examples or the presentation and case studies, like I just gave with that example, or you showed the video, pausing, and offered some opportunities for interaction. At the end, you've met the requirements now for interactive training for your employees. Let's document it. So that can be a sign-in sheet. Many of you are using sign-in sheets for other quality assurance type reasons, or and the farm program for dairies, you have to use sign-in sheets. So just like we've signed people in coming in here, you could certainly make a sign-in sheet, simply pass it around, get everyone to sign that they attended this training on this date on this topic. And then you put that in your training file and retain it. You can also keep the information in individual employee files. So you could simply make a note or have a sheet that individuals sign and put that into their individual employee file, or electronically. People are increasingly going to electronic human resource records. You can simply make a note in there that the training was completed on this date and that date and so forth. There are no specific requirements about whether or not the employee has to sign any particular document. Simply a sign-in sheet to document that this training took place and this person attended. So that's all we're going for that. So we're recording individual files. It's not required by the state, but highly recommended. And the bottom line, the last bullet there, is that your records could defend your business against enforcement actions or against an unwarranted lawsuit, showing that you've met the requirement. Because the liability is there, and I won't jump into that too much because I know Kelsey's going to get into it some more. But you don't want to put yourself in a position of increased liability if you haven't done this training or done it correctly. State's resources are available, and Cornell provided farm-focused training resources. You can also develop your own, but it must meet state requirements. Take time to customize things for your farm, both your policy and that sexual harassment policy notice or poster. Conduct the training and discuss the cases with employees, and ultimately document everything that you did. And if you do that, follow all those steps, you should be in compliance.
I will be next up to discuss some of the risks. Most of my presentation reiterates what Attorney Michael Schiatti said at the Labor Roadshow. So for those of you who couldn't make it, it's a bit of a condensed version. He was very, very detailed. So we just wanted to hit the highlights in addition to a couple other points and reminders as they relate to your business. So with that, I will give the absolute disclaimer that I am not a lawyer. I'm not an attorney. I do not have a law degree. Again, I'll be going over what information attorneys provided us to then provide to you. This is just a little bit of my background. I'm originally from California, graduated from Cornell, worked with Farm Credit East prior to this job, and have been with the regional team for 3 years. So what I will go ahead and go through for you guys, I will try and keep this interesting because a portion of this presentation really is just law codes and numbers and some of that. So I like to think of it as a good cop, bad cop. There's good sides to these policies and bad sides to these policies. So good cop, so what is the point of having a policy? This is something that we've been trying to really identify, beyond just the fact that it's a regulation we now have to follow. Why should we be doing it? So one of the reasons is it clearly defines expectations from the get-go with your employees. So right from the beginning, they know what appropriate behavior is. Secondly, it clearly defines behavioral norms in your business, so the way that people should behave and the culture. And thirdly, it clearly defines what actions will result in termination or in disciplinary action, and for the process of investigation. So that's really what the policy will provide you. It also demonstrates that your business takes this seriously. When you hand people a piece of paper or a digital copy of this that shows that, we've filled it out, we've really thought about it, this is what our business believes and how we expect you to behave, it demonstrates your commitment to it. So all of that, of course, is under the condition that you actually go over the policy and use it accordingly. So the flip side to this, the point of having a policy, is that number one, it informs your employees how to file a complaint with or against your business. It basically gives them a blueprint for how to file a complaint that then follows up with you need to address that complaint, potentially investigate to some level. The next level of this is it educates your employees on how to sue your business. So it also educates your employees on how to file a further complaint if they are not pleased with your addressing of the complaint they filed directly with you. So we're talking about, a piece of paper that's good culturally for our business, but also teaches our employees how to sue us. So at number 3, it indicates what your business could be liable for. So to some degree, these policies really tell your employees this is what they could be entitled to should they present or should they not feel that they have been treated fairly or that their complaint was addressed to their standards. So what I will clarify too, though, is not having a policy does not prevent complaints. Okay, so that's something we need to remember. Even, if the thought process is, well, if I don't have a policy, then my employees won't know how to do any of this. That will not prevent complaints. If anything, it will cause more problems and more likely for you to end up on the wrong side of that legal action. So with regard to training, the good cop side of this, hopefully with training, we can help prevent some fires. So number 1, we want to ensure that employees have read and understand the policy. So that's really the point of the training, right? Because we can give them this 10-page document, but did they read it? Do they know what it means? Do they understand it? So the training gives us an opportunity to go over that. And I will, as Rich said, that this is part of the reason why we can't just send employees to the internet for the entirety of the training, is that it explicitly states in the regulations that the training must address your farm's policy specifically. Now, you may have just used a policy from the state without any special clauses or special regulations, but still, your policy indicates where they need to file to, and who they need to talk to. So those are specific to your business. So no online training is going to tell them that. You have to include that in the training. So that's the good side of this. It ensures that your employees know who, what, where, when, and why they are protected. So the training can further, hopefully, explain to employees what sexual harassment is and what it isn't. So that way also you're not getting a complaint over everything, so to speak, right? Or a little bit of the, not that we want to belittle this by any stretch, but the crying wolf scenario of everything is sexual harassment. We don't want that either. We want to educate employees as to what it is and what it isn't. So ensure that employees can identify and recognize harassment of any kind, not just sexual. So I'll go over it in a couple minutes. These policies, while titled sexual harassment, are actually designed, as Mary Kate indicated, to protect many other classes of people and protect against basically all forms of harassment. So training, I'll remind everybody, must be done by October 9th. So the bad cop side of this is, as far as the point of providing training, you must inform your employees, again, verbally, just in case they didn't read it, how to file a complaint with or against your business. The bottom line, you must educate your employees in person how to sue your business, not just via paper. And it also indicates what your business could be liable for again. So you're explaining to your employees in that training when you go over your policy that these are how you do these things and these are the steps. Again, training must be done by October 9th. So the special add-on that Rich talked about, because as if all of this wasn't enough, is that your employees' behavior towards outside non-employees is indeed something that you can be liable for. So what that basically means is, while it's your due diligence to train your employees, you need to address and potentially take action when issues or complaints arise with your employees involving maybe like an outside consultant, for example, or someone who is just on your farm very briefly for some reason. So you must train your employees to know that if their behavior towards non-employees is also covered or protected. So that goes both ways. If your employee comes to you and says, I had an incident with someone who was on the farm, you still need to address it. Or if someone from outside the farm comes to you and says, I had an incident with an employee, you still need to address it. So this is the extra little bit of this that I wanted to clarify to everybody. So how complicated is sexual harassment? I'll throw in my disclaimer again. I am not an attorney. When Mike Scotty talked about this, one of the first things he said, though, for the most part, it's common sense. Okay. One of the struggles with that, though, is, does everyone have common sense anymore? So while we say that it's common sense, we do need to go over what that means. We have to explain common sense to some folks. So, and with this, again, if you're ever unsure or questioning or can't quite identify if, if the complaint would qualify or this sort of thing, we always recommend, when it concerns items like this where they could result in legal action, if you're not sure, the best place to turn to first is an attorney who specializes in labor law or employment law. So if you're ever having some doubts as to, does this qualify? Should this person file a complaint? I'm not really sure how my business should respond. One of the first places you should turn in most cases is indeed an attorney. So straight from the horse's mouth, Attorney Mike Scotty from the Labor Roadshow. This is one of those things that I'm just going to address as we go through kind of what it would look like if an employee filed a complaint with your business. So that's how we get to the liability portion, right? So when someone comes to you with a complaint or an issue, the first thing you need to do is to make sure that they are physically safe, okay? Number one. So there's really, I would consider it two different ways of looking at this, right? Someone comes to you with a complaint, for example, and says, I was just assaulted in a bathroom or something very physical. The first thing that needs to be done in that situation is obviously to get that person to a safe location, identify who they are accusing of doing this, and potentially call the police, correct? We're talking about a physical endangerment. So when you're trying to protect the risk from your business, that's the first thing to consider. Is everyone involved in this situation? Can we get them physically safe as soon as possible? And do we need to call the authorities? Now, the second type of complaint you will get or might get in your business is someone comes to you and says, 2 years ago, so-and-so made a pass at me and it made me really uncomfortable. Okay, well, they're probably not unsafe at that moment. Now that person who made a pass at them may not even work for your business anymore, or they might. However, in that situation where there's not, I guess, that super immediate action or the need for outside law enforcement, the next thing to ask them is, how can I help you? Right away. How can I help you? That's the phrase that he was very diligent to make sure we knew, is how can I help you? And if that person says, well, I don't feel comfortable at work right now, or I don't feel comfortable working with this person right now, remove them from the situation as quickly as possible. Do that sort of thing to then proceed with the next step, which would be to give them a complaint form to file a formal complaint on paper. The flip side to this is, don't make promises, claims, accusations, or judgments. So this is a tough one. It may seem when someone comes to you with the reporting of this that the situation is very straightforward, and that, another employee in your business may have done something that you find really kind of appalling, right? Or said something really terrible. It's important to keep your emotions as the evaluator and the owner in check, and realize that you have to act very diligently and methodically in this situation to protect your business from any future liability down the road from either the person who is making the accusation or the accused individual. Because of course, we need to investigate the situation. Just because somebody files a complaint or makes a complaint against another individual in your business does not necessarily mean that that complaint is true. So why that? Why do we ask, how can I help you? You're not obligated to act immediately. So these new laws don't say that because someone makes a complaint against another employer in your business, you automatically have to fire them. That's not what this new law means. The ideal situation is to trust people when they make a complaint or when they file with you, but to verify what's happened. So some situations may require immediate action while others will not. In New York, you must hear both sides. So meaning that you have to confront the harasser about their version of the incident. So from that, of course, if you're uncomfortable doing that or feel like you need a third party or a second set of ears to listen to both sides of the story, that's highly recommended. And that may involve contacting an attorney to sit in and listen to both sides. These situations sometimes will be very straightforward and other times will be very gray. So really make sure to assess at the beginning, right when somebody comes to you and tells you this, do I need to get someone else involved from the get-go, or do I feel comfortable moving forward with researching this incident myself? So what does the law actually do then? It allows your employees a safe space to file a complaint or report an issue. So be sure to do extra due diligence with your supervisors because they have as much liability to your business as you do. So as Rich pointed out, and I need to reiterate this, if you have folks in your businesses that are managing employees, okay, have a supervisory role, they are non-owners. So in a lot of cases, this may be family members who are maybe the younger generation in the business who don't actually have any ownership, but definitely have a management or supervisory responsibility on your farm. They have as much liability to your business as you do. So if it is later proven through legal proceedings that they either knew about the harassment, so had witnessed it, heard about it, anything like that, or that a complaint was filed with them that was not addressed, your business will be treated as liable even though they are not an owner. okay? So that's a really important factor to make sure our supervisors know, understand, and can recognize harassment, perhaps even more so than just our regular employees, or at least that they understand their requirements to know and report, and then obviously take action on the complaints. I will also clarify that there are other forms of harassment. So harassment on the basis of sex, disability, predisposing genetic characteristics, familial status, marital status, domestic violence victim status. Your policy should include the catch-all phrase that basically says, it'll say this policy addresses, sexual harassment and all other protected classes per New York State law. So you should have that catch-all phrase in there that covers all these other classes of folks. So my next slide says, if you have it, use it. So this policy, if you deviate from your policy for any reason, you are opening the door for a jury trial. So what I mean by this is, we've had situations, or I've heard about situations on farms where there's been a complaint made against, a beloved employee, somebody who's a family friend. You could never imagine them doing this. There's just no way. You know them, and the complaint maybe is made by a new employee or somebody that you don't feel has great moral character based on their performance in your business. We need to set those emotional and personal attachments aside, because all complaints need to be treated exactly the same. So even if it is a beloved employee, a family friend, whoever it is, there needs to be an investigation. And again, while I recognize that may be very difficult, and if you as an owner identify that that is something you cannot be truly objective about, bringing in either a lawyer, a second owner, someone else outside is very important, because again, everybody needs to be treated fairly in these situations. Mostly because as well, if you don't show that level of, I guess, methodical treatment, equal treatment of everybody, you open yourself up for discrimination lawsuit cases or retaliation lawsuit cases. So those are totally separate even from the sexual harassment lawsuit, right? Now we're talking about other reasons to be sued. So, and yes, this includes you as an owner. You must obey the policy. So people in your business have the right to file a complaint against you. So that is another reason why I would also recommend, when we talk about who's going to deal with these complaints as they come in, it would be wise to have one or two people, right? Just in case the complaint is against either of you, that you would obviously then not be totally objective in evaluating. So bottom line, what is my risk? This is what we're going to talk about next, which is filing or claim filing, damages, and remedies. So if an employee feels that they were not treated fairly by you as an employer with this matter, they can file a complaint with either the New York State Division of Human Resources or a federal claim with the EEOC. So there are two methods that, if they file a sexual harassment complaint to you directly using the forms that New York State has provided after they've been trained, and they don't feel like you have addressed this situation adequately, they have two options: either take it to the state level or take it to the federal level. So the note on this, if the employee does not inform or file with you or a manager over this particular claim, you could most likely still come out okay in this situation. And so what I mean by this, when Mike Sciotti, when the attorney talked about this, was just because somebody takes it to the next level and files a complaint with the state or the Fed does not mean that you will automatically be found in the wrong or something like that. If you have provided your policies, if you've trained your employees, and then also if they don't actually use the system you have in place on your farm to file a complaint with you first. So this would be the situation where, let's say an employee has, there's an incident where an unwanted advance is made by another employee. They never tell you about it as the employer. Nobody sees it. No supervisors see it. It goes completely unnoted. And then all of a sudden they go straight to the to New York State Division of Human Resources and say, you never dealt with this sexual harassment incident, and now I'm going to sue you. That, in that case, because they did not follow the procedure and you trained them as to what the procedure was, right? So you gave them the policy, you gave them the training, they never did that. That's not a situation where you would most likely end up having damages or being liable. Note, if the employee does file a complaint with you, you investigate, you act, but they are not perhaps happy with your assessment or action. This does not necessarily mean that, again, you will be liable for damages. If you follow your policy to the law and go through that process accordingly, diligently, there is still absolutely a possibility that either of these court levels, whether it be New York State or the EEOC, that they will find that you were in the right and that the person who filed a further complaint against you was in the wrong. Very often, we just have to remind ourselves that there is always the option to file and to continue to sue or pursue further legal action, but just because someone starts to sue you does not mean that they will win. With all of that, though, is all the more reason for document, 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 okay? Everything you do, every decision that's made, it's best and recommended, we would say, to write it down, have whoever's involved in the incident sign that they did have that discussion, so have them sign a piece of paper for who was, maybe even who was in the room. And of course, having more than one set of ears is always a best practice as well. So really, just this is more of the, I guess, nitty-gritty details items, but the limitations period as far as filing with the EEOC is 300 days. And then once the right to sue letter is issued, there's 90 days to sue in federal court. So these are the various types of damages that folks can pursue. They can pursue equitable relief, reinstatement, back pay, front pay, compensatory damages subject to a cap, punitive damages subject to a cap, attorney's fees, and pre-judgment interest on back pay. So those dollars can add up in a hurry. And if you figure too, when we talk about 300 days to file a charge of discrimination with the EEOC, which is basically what the employee would be saying, is that when you addressed their claim of sexual harassment, that you didn't address it properly because you were discriminating against them. So if we go from that process of 300 days, that's quite a bit of interest for any of those items. So the next one is just to clarify for some of the damages. The damages limitations. So this just explains that there are some damages limitations, as it said before, for compensatory and punitive. There's a cap. And it's based on the number of employees as indicated on your screen. So for filing damages and remedies through the state, for the New York State Human Resources. So there's the same pretty much damages of back pay, front pay, compensatory damages, however, not subject to a cap, prejudgment interest on back pay, and attorney's fees. So of course, you're going to need an attorney to help you navigate any of these situations. So if you do receive any notification that a complaint has been filed against you through New York State or through EEOC, obviously the first person you should contact is your attorney. But in addition, with some of these damages and relief, you could be subject to paying this other party's attorney's fees as well. So the limitations period for this is 1 year to file, and then 3 years to file in New York State Supreme Court. So why should I train people? Why should I do this training? This is just one of the examples that the attorney had given us. Basically, the plaintiff ended up being awarded $168 million in damages. The company had a written policy, but did not do the actual training that was required, and ignored culture in which sexual jokes were tolerated. So I've seen a request in here for more examples or case studies would help people identify this. What I will say to folks is we're a little bit, obviously we have case studies in the proceedings that you guys will get, which are very specifically laid out. While we struggle, we want to provide some examples. Every situation is so different. It's difficult for us to walk through an example and then give exactly what you should do, because there's a lot of nuance involved. But this is a good example, I guess, of these things can happen on farms all the time. So I will give, I guess, a really easy example of, you have a consultant or a new young person, let's say a young lady that comes onto the farm, and the farm owner says, oh, are you going to be my new consultant? Because you're a hell of a lot better looking than my old person was. Okay, that's just a classic example of things that should not really be tolerated in your business. While it was not meant maliciously or not super overt, it also would be classified under this and could have a complaint filed for that. I'll give another example that a farm has shared with me, that one situation where two employees were making kind of lewd or sexual comments about another employee. So we're not talking, right, I guess, about a confrontation, right, where one employee is directly sexually harassing another, but where two employees are having a conversation and one of them is making lewd comments about another employee. So what ended up happening was this employee who was listening to these comments really didn't approve of this and felt very uncomfortable and ended up filing a complaint. And anyways, they pursued from there. So it's not always what we perceive it to be. So the shop talk can sometimes be one of the, I guess, worst places for this to occur. Even if you're not saying these comments to someone directly, if you're saying them to someone else about an employee, or if an employee is saying them about another employee, those can all still be grounds for complaints to be filed. So the next I will get into is in New York State. Okay, so this one, the plaintiffs were awarded $1.2 million for sexual harassment by a jury in Syracuse, New York. Okay, so this was in 2019. This just happened. And what happened was they ended up filing through EEOC in Buffalo. So they took it to the next level, right? Beyond the employer. That $1.2 million, just to equate it for those, I guess, who are dairy farmers in the room, that's 1,000 cows that you would have to sell to pay that legal bill. Okay, that's a pretty large amount of money. Now, I don't mean to totally terrify people, but that is a very real possibility. If you don't take this seriously, things can escalate quickly. So your best bet is to, get your policies in place, do the training, follow your policy, behave diligently, methodically, and document, okay? And really bring in that help when you need it. Claiming, again, a couple more notes on some of this. So this is when we talk about retaliation. Obviously, we want you guys to take action with these items. However, that does not mean taking unjust or overreaction, okay? So do not fire anyone or take any reprimanding action if someone files against you. So what I mean by this is if someone files with the EEOC or New York State, well, obviously from an emotional level, it's very difficult, right? I can imagine most farms would be offended that, this person didn't believe you treated them fairly when you probably did your best. However, that person has not, per the law and per most handbooks, committed a terminable offense, right? Or a termination offense. So we've got to be really diligent that we continue to, give them the same shifts that they've always had. Don't change any other behaviors. As long as their behavior is consistent as far as the rest of your employee policies and handbook, they continue to do their job, they continue to show up, they continue to perform adequately. There needs to be business as usual, even while all of this is going on. But of course, if they do file a complaint, the first person to call is a lawyer. Note, immigration status is completely irrelevant in these matters. Everyone is still protected and can still file next level complaints. So this is a huge topic right now, with various people using various forms of either guest worker programs or visas or anything like that. If at any time any person files a claim, like a regular claim with your business at the business level, or files a further claim with the EEOC or New York State, their immigration status is completely irrelevant and the claim will be proceeded with as any other one would. So the point of that, I guess, to communicate is all employees, regardless of legal status in the country, will be treated the same under the eyes of these rules, regulations, laws, and procedures. So I will take questions. Of course, my last words of wisdom are ask your lawyer always if you're unsure. As far as the other example goes of these things on farms, we have to remember that to some degree, what people perceive as harassment is going to vary from person to person, and it can be a gray area to try and address. Do your best. Of course, we said in there common sense, and of course, ask for help and resources. That's a big one. If you're unsure, head right to that attorney or another trusted resource or another outside consulting firm, whoever that may be.
My name is Libby Eiholzer. I'm the bilingual dairy specialist on the Northwest New York Dairy Livestock and Field Crops team, coming to you from Yates County today. Let me see if I can get my mouse to work. Yes. Okay. So my topic is, what are some other resources that farms can utilize in order to comply with the state law as far as training goes? Since I speak Spanish and I work with dairy farms, I do quite a bit of training on farms revolving around helping employees understand kind of the science and the why behind what they're doing. I also do some safety training. And I think because people see me as someone who speaks Spanish and does training on farm, a lot of farms immediately assume that I would be going all over Western New York providing this training for farmers. And that's, part of the reason, a big part of the reason why we worked together with this group to develop some training materials in English and Spanish that are going to be available to you to use them on your farm. We tried to make it as simple as possible so that I won't be spending the next 12 months doing sexual harassment training on every farm in my territory, as fun as that sounds. So despite that, I think that we are still going to have some farmers coming to us or, amongst themselves saying, even though there's these resources available, I still don't want to train my employees. I don't want to be in charge of it. I know I have to do it, but I don't want to be the one doing it. Some of the reasons that I've heard from farmers that they don't want to do it is because maybe they don't speak Spanish or their employees' native language well enough. Some people really just might not feel comfortable even asking or answering questions in order to make the recorded training interactive. Some other people have told me that they just don't think their employees will take them seriously enough if they're the ones giving the training, and they'd rather have someone outside be in charge. I'm sure some will say, I'm just uncomfortable talking about this. Maybe they just don't like kind of giving presentations or trainings, or maybe they're just too busy and don't have the time to devote to this. So with that in mind, I did some investigation on what are some of the other options that are available for providing this required training. I have a little issue with my slide here, but basically I looked at what are the options and kind of in general, how much are they going to cost? So I looked at independent consultants probably being on the cheaper end, insurance companies, human resource management firms, and financial firms that you may already be working with for your farm business, those kind of being mid-range, and then the most expensive being law firms or individual lawyers. Disclaimer, as Kelsey said, I'm also not a lawyer. In addition, these are really just generalizations based on my research. You'll need to do your own research with providers based in your area to have accurate information. So I'm just going to go through these different options. The first one being the independent consultants. So what this training provided by them might look like would probably be someone who already works with your farm, coming to your farm, providing an in-person training. So in the dairy world where I am most comfortable, this might be somebody that's a consultant through your nutrition company, through your vet clinic, might be an independent consultant that does some translating or brings in some additional training resources for your employees in other areas. I have spoken with a few independent consultants that have already kind of picked up on the state's training, made their kind of own adjustments to it, and are offering that to farms in their area. The pros that I thought of when thinking about independent consultants that I know are that these people may be bilingual and able to offer the training in the required language on your farm. They're also more likely to have a knowledge of agriculture and a knowledge of your business, which would allow them to customize that training in a way that will make it more meaningful to your employees. And lastly, if it's someone that's already coming on your farm, works with your employees, they may have a rapport with your employees already and just make the training a little bit more interactive, comfortable, and overall useful for your employees. Some of the cons may be that this person could have limited experience in this subject matter. I guess a side note on that would be that all of the extension educators that brought this training to you today did not consider ourselves, experts in sexual harassment prevention. Certainly not when the law was passed, and we've just all been spending quite a bit of time getting up to date. So that's not to say that an independent consultant couldn't have done their own research and be completely up to date and knowledgeable. But then the last factor of here I have as a con is that they may have limited availability. If they're having, they have a full-time job already, and then every farm in their county or area is asking them to do this, it might take a while for them to actually get this scheduled and completed on your farm. And we're in July looking at this needing to be done within the next few months. So I lumped together here insurance for agencies, financial firms, and HR firms. These businesses are going to offer probably a little bit of a different type of training. Some of them that I spoke with have some kind of an online interactive course that you can sign up your employees for and they can complete online. The way this works, generally from my understanding, is that you would get in touch with this company, sign up to have this training available for your employees, and then it's kind of like a per person charge. So one that I talked with, they were charging $35 per employee to take this online course. And that can be, hopping over to the pros, that can make it really easy to administer, especially when you have new employees. So you can have them take this course anytime throughout the year, including your annual once-a-year required training. Some of these companies may also offer in-person trainings where they would come out to your place of business, or maybe have a couple businesses, a couple farms come together to receive that training. And then lastly, I found one company based in Rochester, New York, that had trainings at a regional location on a regular basis. So I can't remember what it was, every third Thursday or something at this auditorium in Rochester, you could send employees to receive this required training. So again, going over to the pros column, these firms are certainly going to have quite a bit of experience in this area. Some of them they may be developing the trainings themselves, or they might be outsourcing it to a firm for the online courses, especially outsourcing it to a company who specializes in creating these online courses and then just updating them for certain state laws. As I mentioned, easy to administer, including new employees. This could be you're sending an email requiring them to do the training on their own. And then a lot of times they'll have an employee training compliance tracking. So if you're kind of the administrator of your account, you send this email out to 5 employees, and once they've gotten it done, you get an email saying, they've completed it. So you've got a documentation and a record of it. On the cons end of it, the basic thing is this is going to be probably not as customizable, especially the preset online courses. Lastly, looking at law firms, as I mentioned, probably going to be the most expensive. One law firm that I spoke with quoted me in the range of $500 for, just a one-time training that was a couple hours long, and then up to, for a full day, a couple $1,000s. And that's regardless of how many people. Again, this is going to certainly depend on the lawyer, your region, etc. But just to give you a general idea. So of course, these are going to be probably in-person trainings. A law firm I talked with mentioned that they offer some additional training. So they offer a training specifically for managers that gives them an idea, supervisors, to help them understand their additional requirements, as well as some, just the general employee non-manager trainings. They may offer some other trainings. For example, one that seems like it would be a good one for this audience, investigating sexual harassment complaints. So, okay, you get yourself up to speed, but then what happens if you actually have employees make a sexual harassment complaint? On the pro side, these lawyers are probably going to be have a lot of expertise in this area. There'll be more options for customization. And then, like I just mentioned, there's going to be some possibly multiple offerings available. One con that I thought of is that, depending on the person and, or depending on the lawyer and their personality and everything, it could be a plus or a minus on employee perception. If you have a lawyer in a suit come to your employee break room and talk about sexual harassment, I think may not be quite as relatable. But of course, it depends on the individual lawyer. Now, the next aspect here you certainly have to think about are what are the risks and concerns that you should have if you're thinking of outsourcing your sexual harassment prevention training. The first thing that Rich, I think, mentioned earlier is, are the materials New York State compliant? So New York State has some very specific requirements, and we want to make sure that we are meeting all of those through the training. We also want to make sure that the training materials are up to date, that they were produced after the new law went into place last year, 2018. One thing that Rich and I ran across as we were working on kind of developing the farm-focused sexual harassment prevention training are the specifics for your business addressed. So if you're just having them do an online training, if you are showing them a video, you need to make sure that your employees are being told who is the person on your farm that they need to go to, how do they reach them, where do they get the complaint forms. So that's something that if the specific training method or trainer can't address, then you still need to be addressing that yourself. Next, if someone else is doing the training for you, are they documenting the training, and are you able to get a copy of that documentation and filing it for yourself. Because if you, again, it's not required to document it, but if you don't document it, then you have no proof that you actually did it. And then lastly, can you provide training for new employees? So what is your game plan for after October 9th, everyone on your farm has received that training, but what about the next person that you hire, maybe October 10th, that hasn't received the training? Are you going to call back in that outside person to do it, or are you going to have a different method for training new employees as they're hired?
About what we learned today, summarizing some action items, and updates on some labor functions that happened in July. But first, my name is Nicole Tamel. I'm the Central New York Dairy, Livestock, and Field Crops Team Farm Business Management Specialist. Today, we're coming to you from Herkimer County in the heart of the Mohawk Valley. So from there, let's move on to our presentation. Okay, so in Mary Kate's presentation, we talked about the new rules affecting sexual harassment at the farm level. Remember, time is very important. Time to get this done is now. It needs to be in full effect by October 9th of 2019. And we do need these rules, and the reason is it's an ethical reason. It's a business reason. It can open you up for liability. And of course, we have some regulatory issues coming down from the state. So going back to your handout that was provided to you, you will be able to kind of look back after you've kind of decompressed and to start moving forward with different rules and regs that are required for you by the state of New York. The timeline that Mary Kate showed you, basically here we are right here. We're coming on to October 9th, deadline for employers to complete a sexual harassment prevention training for employees, which must be interactive and delivered on an annual basis. And I think that we received a lot of information today that will help us at least get through that November 9th deadline. Then Rich came through and spoke about the resources that are available. There are some state-provided resources. You all will have an opportunity to go to the links and review for yourself. The requirements are a policy tailored to your farm. There are, again, different items that you can capture off of the New York State website to help you tailor that to your specific farm. They must be interactive, so there has to be some type of question and answer or a discussion that concludes during your presentation. Training at hire. There needs to be an annual training for the team. And of course, as everybody's mentioned, document. We need to document everything. So CCE has began to develop and is in the middle of developing some farm-focused materials, which will be a simplified language. It will be available in English and in Spanish. It will be much more appropriate than the New York State canned case studies for farm situations, and all of our materials have been cleared through the New York State Department of Labor, so you know that what you're doing on your farm is applicable and you are within the letter of the law. Kelsey, her conversation actually elicited a tremendous amount of response, so thank you, Kelsey. The legal concerns, compliance and implications, and risk. So policies are needed. We have to make sure that we have policies. We need to define expectations of the employees. We need to define the behavioral norms at the farm level. We need to figure out termination proceedings if rules are broken. We had a lot of discussion here at my group about termination proceedings. What happens? That's why it's very important to have a farm handbook, some type of employment handbook, so that we can detail out everything that happens on the farm and employees are held accountable for knowing and understanding that. And we have to remember that business is a serious place of employment. Our businesses are actually businesses. They're not, it's nice to have fun and enjoy your job and enjoy your work, but again, they are a serious place of employment, and we need to really focus on that. When someone has a complaint, always, always, always make sure that they are safe, and then ask, how can I help you? That came from Attorney Schiatti. Have a policy, use it, or you will be subject to a lawsuit. I really like this little Toy Story, compliance is everywhere, because Buzz is saying it is. We have to be compliant in everything that we are doing. Employers must provide training to employees that is state mandated. We can utilize outside vendors, consultants, law firms, etc. However, there is a cost involved, and Libby really did a nice job laying out the pros and cons of going from a person coming on your farm through HR specialists all the way up to an attorney. But please be aware of possible issues with that training. We need to make sure that they are New York State compliant. We need to make sure that they're relevant. As we had mentioned earlier, if it's a few people around a water cooler in an office type setting, a lot of our farm employees, they can't relate to that. So we need to make sure that our trainings are relatable and they need to be up to date. So something that is 5 or 6 years old is not going to really work for us. So a few other notes to discuss. There are some labor updates. Many people have heard that as of July 17th, 2019, Governor Cuomo signed into the Farm Workers Fair Practice Act. The full law will take place and be in effect as of January 1st, 2021. New York Farm Bureau, as well as other agencies, did a lot of lobbying to change the law from 40 hours per work week to 60 hours. So it'll be a 60-hour work week. Overtime will be paid at time and a half after 60 hours. There will be a 24-hour consecutive rest day period imposed. However, if that person decides that they would like to work that day, then on the 7th day of work, we would be required by law to pay all hours at a time and a half pay rate. So we're just kind of going over just a few little updates that we want you to be aware of. And of course, as everybody's heard, there's also will be some collective bargaining abilities at the farm level. Another part of the law, and this will actually take place as of January 1st, 2020. Farm laborers will no longer be not exempt from the Disability and Farm Leave Act, Family Leave Act, excuse me. Employers will need to have a disability insurance in place along with a paid family leave rider. Disability can be partly funded by employees and a balance paid by the employer, paid fully by the employer, but there can be some funding through the employee and money taken out of their weekly pay. Paid family leave rider can be fully funded by employees, or the employer can elect to pay for some of the coverage. And we will actually talk more about that in the future. I just wanted to give everybody just a quick little note what's going out there. And then certain waivers do apply for the family leave insurance. So again, all that information will be coming down the pipeline in the next few months. And then finally, to stay current on ag workforce development, please go to this website, agworkforce.cals.cornell.edu. All of this stuff this week will be up online, as well as more information from the work that we're doing as a team. So please utilize this. It's a great website, and there's been a lot of work done to this website. So http://agworkforce.cals.cornell.edu. Even if you go into the Google bar and write ag workforce development at Cornell, it will pop up. So it's a great website. Go and review it. You can also click in there and get updates from Rich. You can go and just subscribe to and get updates. So that's it. Thank you.